This video is a project of the Legal Aid Society of San Diego and was produced in January 2026. This video provides a general explanation of the California eviction process, with some mention of local laws. It was updated in January 2026. Please remember that laws and regulations are frequently updated. This video is for educational purposes only and should not be considered legal advice. Step 1 in the eviction process requires a landlord to deliver a termination notice to the tenant. A valid termination notice has three main requirements. It must be on paper, include all required information, and be properly served. The first requirement is that the notice must be typed or handwritten on a piece of paper. A text, email, or verbal statement is not sufficient to start the eviction process. Second, the termination notice must include specific information to be valid. This may involve statements required by state or local laws, such as information about relocation assistance, buyout agreements, or a just cause for termination. The notice must also state the number of days the tenant has to move out. Third, a valid notice must be properly served. California law provides three ways: personal service to the tenant, substitute service to another adult, plus mailing a copy to the tenant, or posting on the tenant's door, plus mailing a copy to the tenant. If the landlord delivers a termination notice and the tenant neither vacates nor fixes the lease violation, the landlord must move to the court process before a tenant can be removed in almost all cases. Self-help by landlords is illegal. This includes removing the tenant's belongings, cutting off utilities, or changing the locks to induce the tenant to leave. Step 2 begins when the landlord files a summons and complaint with the downtown courthouse. The court sends a notice by mail to the tenant, and the landlord has a copy of the summons and complaint personally delivered to the tenant. The tenant must file an answer with the downtown courthouse within 10 court business days to preserve their right to assert defenses in court. If an answer is filed, the landlord may request a trial. The tenant must attend the trial. If the judge rules for the tenant, they stay. If the judge rules for the landlord, the tenant must vacate, or the landlord can ask the sheriff to lawfully remove them. Let's review this important summary. Landlords must follow the court process to evict. Evictions have very fast deadlines. If you miss the deadline, you may automatically lose your housing. If you receive a lawsuit, you only have 10 business days to file your response in the downtown courthouse. Your response is called an answer in the courts. If you do not appear at the trial, the landlord may automatically win.
We hope this has been informative. For additional resources, please visit the rest of our website at housingjusticecollaborative.org.